Just thought there was something else worth saying about prosecution of the members of Parliament. So we've got quite a lot of few new clauses. Well, not new to me. New clauses that I didn't know about before regarding prosecution of members of Parliament, including the House of Lords as well. So it seems like the privilege of the peers of the Lords is in fact only regarding their work for Parliament, not themselves as a criminal. It's not like in Magna Carta when lords and barons couldn't be prosecuted by their equals. That's how people kind of think of it. So the whole Jeremy Johnson KC paper is in question, really, over Lord Hanningfield. So there's this provision here, right? It says for impeachment, no pardon under the Great Seal pleadable to an impeachment by the Commons of Parliament, right? Now that is in the Act, that is in the 1700 Act of Settlement. Now there's a citation underneath there as well, right? Don't know what that black spot's doing on there. I think that's coincidence, but I don't know whether it means that if... I'm not sure if they're using the word appeal as meaning equal to a pardon. If in law a pardon is something different to an appeal, but the thing is, they never really had the word appeal in use through prehistory. All the way through, like, you know, all this classic period of petitioning. I think that Henry Burton and John Beswick case is a very good case because he gets prosecuted by the High Court of Commission, but then he petitions the Star Chamber, right? So they just call it petitioning different courts, right? But you could also, the thing is, you can go straight to the higher jurisdiction in the first place, right? But if you've been prosecuted or convicted, people did just be able to petition for you being released, right? In a way, that's an appeal, but kind of from someone else or from another party. In a way, really, I can't really see how a pardon can be different to an appeal, because the thing is, if you're asking a pardon from Parliament or the monarch, it's like to say sorry, but, you know, that's if they were wrong. But then again, if you're appealing, it's usually over something that's been done wrong or on new evidence, so why would you be appealing, you know? But the thing is, I'm not quite sure what the date on this is, but I know from 1700... They made this law, it's in the Act of Settlement, that if you are impeached or prosecuted by Parliament, right, I think that is either house, but the thing is, if they put a bill through to prosecute someone or put a bill through to get something overturned, it goes through both houses, doesn't it? Because bills put through the Commons have to get approved by the Lords, right? Although the Lords can only ask them to change it or amend it. I don't think they can totally block it. So I think that you can get a pardon or what you want to look at it, an appeal from Parliament from other lower courts, okay? Like with this post office scandal thing, they're getting the convictions overturned. But if you actually get prosecuted or convicted by Parliament, supposedly, it can't be overturned. So, like, if they prosecuted Boris Johnson or impeached Boris Johnson, but they've put it in the Supreme Court now, which is odd. But you've still got the Privy Council with judicial powers. They can't really take away judicial powers from committees, really, either. If you read that William Orange, all that stuff to do with the Bill of Rights, or how it happens, through how they deal with it through there. Now, you can read the Constitutional Reform Act, which is what the Judicial Conduct Office are working on now. You got representations to the House of Commons. Gordon Brown was tinkering around and messing around with the whole Constitution with that. But I don't see how you can tinker and mess around with the whole Constitution when the whole Constitution is based on Magna Carta and the Bill of Rights, because those are your basic principles and they give a certain right to Parliament. Now, the thing with the Supreme Court is that it isn't Parliament. You've got some judges in there who are members of the House of Lords, right? Now, even though they might have loads of rules and regulations around that in the Constitutional Reform Act and other acts, right, there's still the law in place and in effect. The law is still in effect and in place. You see that Appellate Jurisdiction Act, where you can appeal to the Lords with a prayer and petition, right? You didn't need that to petition the House of Lords, and you can still petition the House of Lords now. There's no law in the right to petition preventing you from petitioning about any subject, and if they enact that into codified law, if it's in conflict or contradiction with the statute, then it's questionable, you know. But this will be why that they don't really want to. You see, if Lord Hanningfield would have been prosecuted in Southwark Crown Court, right? According to all this, he still doesn't go to prison, though, even though he gets prosecuted. This is what they say in the Corruption and Legal Practices Prevention Acts and all these to do with, election petitions and so forth and so forth and so forth. They started putting some imprisonment stuff in there, right? But that's not necessarily peers who have got privilege or members of Parliament or someone who might have been petitioning. There's another thing that we need to get clear, and some people might think, is an election a petition? Are you petitioning with an election, or is it different? An election petition then is a petition of an election, like trying one. Now, we go all the way back. Elections are something actually very, very, very old. We used to elect the jury, the jurats. We used to vote for them. Now, the thing with the jurats is that we voted for who we wanted, like people that we thought were good citizens. We get to choose them. The principle they've got for the jury now is that they're selected at random. It's completely random throw of the dice of the public. But that might not be a very, very good representation of what it's meant to actually be. If the jurats are meant to be the people's choice of good standing citizens, then the jurats would not be chosen at random. They actually would be the favourites of everyone, of the citizens who they want to represent them in court, who the majority people favour, and not candidates. We're talking about, actually, some of the mayoral candidates. You can have candidates. They had candidates because the mayor used to pick 3 people and then you choose between them. But there's a bit of mystery going on between when these candidates started popping up, because it was meant to be. I think it goes back beyond the conquest before William the Conqueror, this whole election thing. It could go back to the Celtic villages and choosing the kings being elected and the councils being elected to make the laws up in before the Roman invasion, not necessarily hereditary or anything like that. I think that was more like the Druids, people sending off, the wealthy people sending their kids off to learn to do Druidry, which was between all the clans. So the election, in the current law, I'm not too sure whether when you're running an election, whether you are petitioning and you got immunities or not. That's something that they're very intimately tied together. It looks like in the Bill of Rights, elections ought to be free, but then the right to petition that's one question that I'd like a definitive answer to, and I don't really think that. I think it probably would take I think there probably could be an inquiry into that question. There probably needs to be an extensive body of evidence laid before the public to lay out if an election is or is not a petition. Because the thing is, with a petition, you're bringing a case and getting witnesses to support it in evidence, and then you're petitioning the king or the parliament to make a decision. So the people and the witnesses you're not petitioning the people necessarily. You're getting them to sign it. You're petitioning the king, right? Or other House of Parliament. That's who you're petitioning, and you're asking the people to sign it and support it as witnesses, right? Now, with the election, you are asking the people who they want to represent them. They're not asking the king. Unless they're asking the people and then they want the king to approve the person they've asked for, so that's their evidence to the king who they want to represent them, and then the king appoints them or, whatever. Exactly who's being petitioned, the king or the people? If you're asking all the people, is the king asking all the people who they want to represent them, and then they vote in the election, and then that person is chosen or the king appoints them? Have they petitioned the king for that? Or the government, or are they petitioning the other subjects? There's a lot going on in the law with, there was definitely some kind of immunities, but all the penalties were non-imprisonable penalties, like just fines and so forth. 1688 Bill of Rights is way, way later. Now, I don't know whether, this is my question. I have got a question. In the 1688 Bill of Rights, are elections a completely separate thing to petitioning? Because I'm starting to think that petitioning the king or other House of Parliament in a case or cause, that's that case or cause. But for the elections, some of the elections are local, like under the charters for the separate area, they run their own elections in a local area, right, under the, town hall and mayor and so forth, and the sheriff. It's not the election of members of parliament for parliament. That's kind of separate, So, but why it's important is that, so this thing for pardoning anyway, so if you get convicted by any court, what isn't parliament, you can appeal to parliament, right, or petition them, or ask for a pardon from the king, right? It comes from another court or another justice, right? But if you were to get prosecuted by the parliament, which not many people do, unless you actually work, unless you're a peer or an MP, then that's not forgivable after 1700 Act of Settlement. Anyway, that's why the MPs don't really do it. If Hanningfield had been prosecuted, I think Hanningfield could have been prosecuted by the Southwark Crown Court now, or they could have prosecuted him through Parliament. But if they had prosecuted him through Parliament, then he can't be pardoned. But the thing is, what gets me is that if some of these other laws here are saying that for parliamentary work they can't be imprisoned, but even if they get prosecuted out of Parliament, I don't think they can be imprisoned because they've got privilege, right? But you can still prosecute them, which is quite odd. You might think, all prosecutions are illegal. Why would you get prosecuted? Illegal prosecutions by the King's Bench for matters under... So, the other courts can't prosecute the peers for things that Parliament are responsible for making decisions for, but other things they can be. That's separate from you or me doing a petition case to Parliament and is the right of the subject to petition the King and all prosecutions for doing so are illegal, because that's your own casework that you're protected with and things that you need to do for that casework, right? And the thing is, if all prosecutions are illegal, I can't see how Parliament can even prosecute you. So if you are truly doing it for that casework, and that's the honest truth, and you need to do it for that casework, and it's not some other misdemeanour, right? It's in the line of duty, then I don't see how you can be prosecuted by Parliament either, because all prosecutions are illegal, right? Which means that you can't be impeached by Parliament. So you wouldn't be under threat of getting prosecuted by Parliament and not being able to be pardoned, because the Bill of Rights is kind of like an act of indemnity for that work. Now, there is another act called the Act of Indemnity, which gave a lot of people protections, but they were exempted out of it. I don't know whether they can exempt you out of the Bill of Rights or not. They might be able to, and then you might be able to be impeached in Parliament. But one thing's for sure, you automatically get it in the Bill of Rights if you are doing petitioning, and if they don't want to give you it, they've got to exempt you out of it. The problem with me is that I just didn't even think it existed. So, I mean, I automatically have to have it, and then he would have to exempt me out of it and say, well, I'm not giving you it. But by saying I'm not giving you it, you have to say that it exists and that, some people can have it. My judge said that you can't have it. It doesn't, because it doesn't exist, which is odd. He just didn't believe it existed. Whereas with the Act of Indemnity, of course, it exists. But if they want to take it away and say you can't have it, then they have to, they have to remove it. But I'm pretty sure with the right to petition, it's a bit different. It says all prosecutions and commitments for that petitioning are illegal, but that's like in the election petition rules. As long as you tell the truth and answer all questions properly, you've got excuses for what you did and indemnity covering you, then you're all right. But we're talking about things that aren't in the line of duty. A little bit like police, as long as the police, is using reasonable force and they're pursuing a felon, they're covered by their own legislation, which is different to petitioning Parliament. It's a different... the police are pursuing crime in their local area, in a local commission for a local authority. They're not petitioning Parliament or either houses of Parliament, so that they do their job under different legislation. Although we can do policing, we can pursue criminals, we've got the Criminal Law Act and so forth. But the thing is, it's not if you're petitioning Parliament and you're pursuing crime or a criminal, you wouldn't necessarily be using the Criminal Law Act 1967 because you're not going to a court in a local jurisdiction with the case. You could say, well, every single different police force in the whole country is using that as you're going through them all. But to Parliament, I think that you get you don't actually, because it's the whole country and the whole nation. It's like a national jurisdiction, like the Cub Scouts, like under the Cub Scout Charter, funnily enough, ironically enough, under the Privy Council. That's why I don't think that the police's legislation is like, reasonable force, negotiable, arguable in some instances, otherwise can and can't do, like drive as fast as you want if you're pursuing a criminal. Well, I'm not saying, that they should drive as fast as they want, but it says that you don't have to observe the speed limit, so there is no number, no limit to observe. That's legislation for them. Now, every police force is only really operating within their own jurisdiction or commission. Maybe if a police officer goes out of their area or jurisdiction and they're still pursuing an offender, maybe that law is in effect for England and they're still in theory pursuing a criminal. I'm not too sure if they can get them or get another police officer to, bring them back, if they bring them back in. But, for sure, with Parliament, I think it's because it's a lot more serious and a lot more important matter that you would be pursuing. For example, the World Health Organization taking away everyone's rights in the whole of England, quite a much more serious matter than someone's window getting smashed, or possibly even a yacht getting stolen from the harbour or something like that. It's a crime, but and I think this is where there's a lot of silly things that people petition Parliament for, but there's also a lot of serious things as well. And I think that law and that legislation really needs to be emphasised on that seriousness and importance. And I do think that, if you're in the line of that inquiry, in that duty, in that casework, you pretty much, I think you are protected. And also there's jeopardy as well. I mean, if citizens are, police are busy in their job doing, in their area every day, most citizens work. And where do they get their money from? And if you're doing something, exercising a right, and you've only got limited time, or doing it on a weekend, or this police call this special. They've got these specials, volunteers, right? You really are putting the rest of your life and work at jeopardy under the line of duty. So there's a lot to be said about it, really. But I know for certain, if you are doing a petition and you are pursuing in the line of duty, and you've got other misdemeanors that most definitely aren't connected to it or anything to do with it, with the finance and money, it's a bit tricky, because I think that with petitioning, people don't have finance and money, so they've got to use their own. And if you're using a bit for the petition and a bit not, and some of it's non-profit and some of it's not, you're immediately putting yourself in jeopardy trying to sort out your finances. And if you're claiming tax back for non-profit and all that, you're in jeopardy. And so as far as I've seen, they still haven't even given an officially proper claim method, even with that VAT 126. So you're in jeopardy. Now, this is the thing with Lord Hanningfield, with his expenses and so forth. Is it matters and affairs to do with Parliament? Probably, but it is a misdemeanor, though. Expenses scandal is a misdemeanor. Says they can be prosecuted for misdemeanors in between sessions, right? It doesn't actually say. It doesn't say whether it matters, whether it falls within Parliament's work or not. I think an offence is an offence. I think if you're in Parliament doing parliamentary work, and you do, lie or fraud or whatever, I think that's an offence, a misdemeanor, isn't it? The thing is, casework for things that are only decidable and debatable and so forth in Parliament. But then you've got all this Supreme Court nonsense now, where the Parliament did this or that and they're challenging it in the Supreme Court. I don't get all that. That's what I don't like about Gordon Brown with his Constitutional Reform Act and all this Supreme Court nonsense with these three stooges in the Supreme Court, when you meant to have the Assembly of the Lords. To me, it seems to mess things up. And I really don't think that you needed that Appeal Act Jurisdiction Act in the first place. There's a lot of questionable stuff about it, to argue about. With the elections, it looks to me like they are giving some kind of... they had some kind of penalties and fines for misdemeanors for elections, and they had some kind of indemnity and immunity and excuses, but then later on they started changing it and putting imprisonments in, and I'm not too sure about that, because, depending on who you are, unless, it seems quite strange that that act of indemnity, they definitely excuse certain peers out of it, and I think peers got put in the Tower of London, so that means they can be imprisoned at the point of 1688. But that's by their peers, though. They're imprisoned by their peers. So maybe when it says that they can't be put in prison, I think that maybe what should have happened at Southwark Crown Court is that Hanningfield could have been prosecuted. They could have looked at the evidence and then, found out what was what and said, yeah, he did this or that, and that is, now that's fact. We decided that he did do this and deserve that money, but maybe they can't put him in prison, but they can try him. Because his misdemeanor is a misdemeanor. It is an instance where the law was broken, right? It's not an instance where we're going to decide whether, the tax on tampons should be changed or not, is it? The fact of the tampons, this is the thing with Jeremy Johnson KC. I think this is the argument that he was trying to put out in there, but he didn't put the whole evidence in there. If you want to say, the Crown Prosecution Service, I meant to notify you or inform you of, anything that may prove someone guilty or not guilty, disclosing evidence. Johnson definitely framed it pro Hanningfield, that's for sure, rather than, let's get all the facts out and see what the truth is. But that's what a defence lawyer is going to be doing. But then you've got the whole Privileges Committee. Surely Hanningfield must have been reported, or, the Privileges Committee must have been informed about the matter, and then when at the point they look at it and make a decision, isn't that making a decision? That is his peers making a decision on the subject. But what is that decision? Whether it could be heard in court, but why didn't they just hear it? Why didn't they just deal with it? Or whatever. It's getting into a rather ridiculous affair, in my opinion. I think there's a lot more to it than 6 pages of Jeremy Johnson KC. I mean, it's ironic that, for example, my representation was a lot more than 6 pages worth of Jeremy Johnson KC. I put, I didn't have anywhere near as much fact, law, proof, evidence, research as I have now, but I had enough. There was enough. There was more than enough. There was plenty just for the general gist of it, the whole, all the Town and Country Planning Act, the basis of the Town and Country Planning Act, that's it, right? That is it with the Class F, right? That's the model, and in effect in one particular area, but it's the same principle in the other areas of effect, right, for other actions and activities. So that is the model. I don't know how you don't understand. And it's a Criminal Damage Act as well, right, privilege and interest, again. Then you've got that Criminal Law Act, when you're pursuing criminals anyway, which is assisting offenders. That's similar basis, but in the local area and jurisdictions. So, and then there's a Bill of Rights that tells you anyway, it's the law. If it explains, the law explains in the law and the claim of rights. So, and then there's they had special reasons, in quite a lot of the driving acts, special reasons. Why would you have a special reason? Well, because there is a reason that's special, you can have it. It's kind of, it doesn't need to be that complicated. There's a lot more, put it this way, I can't see how this 6 pages here isn't that much of a brainstorm, and the last page hasn't even got more than 3 lines on it. So, it's not, it's full of eloquence and, fancy etiquette, but it's not rocket science. I don't think my representation really was any less complicated than this, probably even more complicated. Maybe that's why I didn't understand it, or it just, I don't think it comes down to understanding it. He was furious. He couldn't handle it. He didn't want it to be. He didn't like it, and that's not why you're there to be a judge. You're a judge there to apply law, And now there's just so much dialogue from Parliament and other principles, and just the underlying basis of the oath of the document, the testimony of the people in writing, a suit. The suit. This is what it was when people in an area, when there was a criminal report, and they had to go find him. Hue and cry, the suit, and if they didn't, they were in trouble. Yeah, but then again, it seems odd that if there are no witnesses, I don't know. I still can't quite work out how the hundreds are accountable. The local 100 are accountable for catching a criminal, and there's penalties if they don't. But yet, if there aren't two credible witnesses, they can't be prosecuted. So, I mean, unless what happens if they can't find any witnesses? Well, I think maybe that's the thing. There were witnesses enough to report it, or else it wasn't officially declared as an official pursuit. I think if they didn't have those two witnesses, then I don't think it qualified for a hue and cry. It wasn't actually pursuable, probably. Unless they had one witness and they had to find any others. I don't know. I'm not quite sure. I'll have to look into it, but it's... Anyway. So, this impeachment... I think maybe that they can be prosecuted, therefore, in between sessions for misdemeanours by other courts or the public. But I don't think they go to prison for that. I just think they kind of get, fines, or it just comes out with a verdict. Because it's through other courts. It's not petitioning Parliament, is it? If you're prosecuting a lord in a court, that's not a petition to Parliament, is it? It's a misdemeanour offence to a court, right? So he can be prosecuted for that, but probably not imprisoned because he's got privilege. Now, if he's prosecuted in Parliament, then obviously maybe he can't have the pardon, which is why, for example, in William Orange, he's exempting people out of that Act of Indemnity. So I think that would... then they're going to get prosecuted, and that's it. I think they're gone then. I think that's it. They're done. That works out. I think that works out in my head. That kind of solves it. I think that's it. But Annenfield had already been to prison. I think he'd been prosecuted by the normal courts, and then the CPS were wanting to just do it again, and they thought they could, we'll just do the same thing again. But I don't think he should have gone to prison. I think he should have been prosecuted, and then he could have been found guilty, and they said, okay, it's been, right, yeah, so this man did this thing, and he's guilty, and now, the facts came out in court, and it's all official and that, but I don't think they should have gone to prison for it. But he could have been prosecuted through the courts. But then you might say, well, why didn't his peers prosecute him in Parliament or whatever? I don't know. The thing is, it says that people can prosecute peers for misdemeanours in between Parliament. Why don't they petition the King instead then? This is the thing. Maybe they could. Maybe someone could put a complaint or grievance into Parliament about a peer and get them prosecuted in there. But, or maybe Annenfield could have appealed to his peers. Maybe it was like an appeal then. Maybe Johnson's representation almost was like an appeal. But the thing is, that would have been after he'd been convicted. But then you've always got that thing that you can ask the King for a thorough investigation and raise the matter to, the Parliament, like Star Chamber or his peers equivalent to... So, but then that would mean that it would have to be investigated and he would have to be tried in the Parliament. And then there would have to be, a verdict. So, and then he wouldn't have been able to get a pardon from that. that calculates all right in my head. If I don't know if you're probably following it or not, but it's a bit complicated, but I understand it. There's it's just like a model. So there was something. Firstly, I don't think that he should have gone to prison in the first place, but I do think he could have been prosecuted. And then the second time, really, why didn't Johnson appeal to the Lords, but then he would have been dealt with by them? But are the Lords giving him a pardon, effectively? Have they decided that? But if the thing is, if they'd have already made a decision that they were going to not find him guilty, then why didn't they do that in the first place when the matter was notified to the Privileges Committee and they were messing around, taking a long time to decide? At that point, in the Justice of the Peace Act 1997 and Courts Act 2003 says that if a resolution by either Houses of Parliament is subject to an annulment, right? So that Old Bailey, why do I keep thinking of the Old Bailey? I just mean the Crown Court when I'm thinking of Old Bailey. But it was Southwark, not the Old Bailey. That's Central Criminal Court, not the Old Bailey. Same level, but different area of London. So Southwark Crown Court, Haddingfield, which is equivalent of Old Bailey, but Southwark, not in Central London. So if Johnson was appealing, if Johnson was appealing before the court made a decision, how was he there? Because if the peers are going to hear it, then it's subject to an annulment. So, but he's not saying that in his paper, though, is he? The thing is, this paper of Johnson's is not saying, Lord Hanningfield is appealing to the Lords, and therefore the proceedings are subject to an annulment because he's appealing to a higher jurisdiction, which he can do. You can actually do that before you've had a thing. So I don't think he's doing. Or he's saying it's. Oh no, he's saying it's under the. They are bringing it under the jurisdiction of the House of Lords for them to decide. So maybe he is doing that. Maybe Johnson is basically saying that he's appealing to the Lords. But then why is he starts talking a lot of tosh about, well, there's nothing really preventing these proceedings from going ahead. Why does he say that? Well, there is if it's subject to an annulment, because but they haven't made an order though. Although the charges could be subject to an annulment. Whichever way you look at it, there's something. Someone's doing something wrong, and it's not me. Someone is in error. There are errors in this. That there are mistakes. There are errors and mistakes in this. And still, what happened with him first time? None of the newspapers reported on it. They weren't telling the truth. Some of the newspapers said one story, then the others said the other. One story said that, the Crown Prosecution Service couldn't believe it. They were furious, and this letter got delivered by email at the last minute. And Jeremy Johnson, Alistair McReef read it out, and then he said, not guilty or whatever, and the jury couldn't hear it. At that point, had they appealed to the Lords, or they already appealed to the Lords, and the Lords already made a decision, or did they make the decision in secret and private later on? But if he could have been prosecuted and then his privilege still applied and he couldn't go to prison, what was supposed to be afraid of or scared of? But yet that would have put into dubious question the first time when he went to prison, which was wrong. He shouldn't have gone to prison if it was done by a normal court. So there's that as well. Do you know what? They're toying with us. They're toying around, and this is what they're doing with Julian Assange. They're toying with Assange. They're playing with him like a cat plays with a ball of wool. You know, that they're moying him around. To none shall we delay, to none shall we deny right or privilege. Well, they delayed Assange's rights, all right, even if he's Australian. No, to no one will we delay justice. So we're being toyed with by these cats, these lions, these ferocious beasts who end up like Jeremy Johnson KC, who's, pottering around in the chambers and, writing 6-page documents for the Lords, and then he gets raised into the upper realms of the judiciary, and then they're taking odd, weird, dark oaths of not being allowed to know when someone does wrong. But yet they're the ones who are going to judge who's done wrong or not. Very odd, peculiar, very peculiar, arcane, dogmatic, these weird mages of majesty. It's almost like, I'm starting to think that, all these mobile phones are stealing people's souls now, just staring into the glowing screen. Everyone's, when the Indians, they didn't like having the photographs taken by Westerners. They were like, oh no, you're going to trap my soul or capture my soul in the camera. I actually truly believe that they are capturing people's souls in the devices. They're trying to capture your attention. Your soul is like your contact to the outer world, like the sole of your shoe, your contact with the outer world. If that is distracted, apprehended, possessed, or otherwise occupied by something, then you are under arrest of it. If your entire focus and attention of life is gazed into the looking glass, it has captured your soul in a way, and then there's all your information on there that it's obviously taken note of and captured, and then it being used by the authorities. Oh, you did this, you did that, and then we're getting all these prosecutions, but not even by a jury that we elected as the public's champions and favourites in conscience. No, randomly selected. And then they take the jury away, and then it's these magic magi, the magistrates, and then they start making all the decisions higher up, and then you get like Assange. It really is. I'm starting to think that it's a very, very, very dark magic, and that's a bit of a strange thing to come out with, but I really think that it is. And then when you find the oath of these people at the top, they don't even believe in the principle that you can't have a civilization, a democracy, a culture where the leader of the culture doesn't really believe in or embody the principles and beliefs of that culture. In fact, he can do the opposite and not be accountable. It seems quite a ridiculous endeavour, really. So that's where I am with it at the moment. I think that the right to petition, you can't be prosecuted as long as you are telling the truth and you were required to do those things in pursuit of, the suit or case, and within reasonable force or within reasonable error or whatever, for whatever it is, conversation finances money or whatever, then I don't think that you can be prosecuted by Parliament. Therefore, you wouldn't need to be pardoned, because you can't be prosecuted for it. So I don't really think that it matters whether you're an MP, Member of Parliament, or whether you're a peer, a lord. It's all down to the suit, I think, really. And if any other misdemeanours are, but I guess with Hanningfield, they're saying, oh, no, his expenses is, Parliament's business, because they're the ones who deal with the money. But then, if that's the case, it seems odd they would end up in that court. Why didn't the Crown Prosecution Service, petition Parliament for Hanningfield?